Good morning, everyone. Thank you, Major Grunert. Yeah, so thanks for tuning in. Thanks to Major Grunert and the Law, Technology, and Warfare Research Cell for the invitation to speak today. Like Major Grunert said, I'm the Chief of Air and Space Operations Law at NORAD and USSNORTHCOM. And if you're not familiar with those organizations, NORAD is a binational command, and so it's a four-star commander who answers to both the government of the United States as well as the government of Canada, and is charged with homeland defense of both countries. USSNORTHCOM is the combatant command in charge of homeland defense for the USSNORTHCOM AOR, which includes the continental United States. And so it's an interesting place to work because we have two commands, one commander, but he wears different hats, as we like to say in the military. And so my position, I advise on all the air and space operations that both commands execute, making sure they're in line with international law, domestic law, and DoD policy. So this is in my personal capacity. All these opinions are my own. I am an Air Force judge advocate, and like Major Grunert said, I had the opportunity to attend the University of Mississippi Air and Space Law LLM program prior to this assignment. There, I wrote my thesis on the topic we're about to discuss, and so I'd like to share it with you today. So this is called Conflict in Space. That's the title because this presentation is all about conflict, both armed conflict between two nation states, as well as any conflicts in laws that might bring about. And specifically, we're talking about international law today. Because space law, I mean, it can be domestic, but we're going to focus on the international aspect because we're going to have those two nation states in a potential armed conflict. Certainly hope that armed conflict never extends to the domain of outer space, but if it does, we need to have a framework in place to resolve any conflicts between these applicable international laws. So a brief introduction, we'll give a brief introduction on why this is relevant now. And then really just provide a framework on if we do have two laws, law of war, international outer space law that apply to a certain activity, military activity in space, how do we resolve that relationship? What if there's conflicts? How do we harmonize them? And I'm going to provide a framework based off of the International Law Commission, the United Nations International Law Commission. They produced a report on this concept of fragmentation. We have these specialized regimes in international law, and how do we deal with them? How do they interact? As a part of this analysis, we need to really understand the history and the objectives of each of these regimes of law. And so we'll briefly cover those as well on each law. And then look at the harmonization between two. And if we have time, I'll go through an example as an exercise on how to harmonize these two laws or regimes of law. So setting the stage, why now? I'm sure many of the attendees are aware there's a lot happening in space, especially military activities. You have the United States, China, and Russia are the major space players in today's space age. And it's also no secret that all three countries are in competition on the international stage. Militaries continue to advance these technologies in space. All three have demonstrated the capability of an anti-satellite execution. Back in 2020, there was a big Time magazine report where the U.S. disclosed this pair of Russian satellites that followed a multi-billion-dollar U.S. spy satellite in orbit. And then one of those satellites even launched a high-speed projectile into space. And that was in the Time magazine report. It's also no secret the United States has the newly recent United States Space Force. We've also brought back United States Space Command. So we have these newly formed military services and combatant commands focused on the space domain. And the other states have space forces as well. It might not be titled a Space Force, but we still have those space forces within Russia and China. So we have these military capabilities advancing, these military space forces, but we also have some strife on the civil side as well. The United States has led the Artemis Accords, but Russia and China are not members of those accords. There's disagreements. There's mining on the moon and asteroids and this future gold rush of sorts, and not all states agree on that as well. So again, hopefully we never get to an armed conflict. But as you can see in the current state of geopolitical affairs, I mean, if there's some type of misunderstanding, if we don't know the rules in place, so now is the time to start thinking about these relationships between the legal regimes. The United Nations General Assembly also has recently taken steps on this very matter, with some actions to try to get states to start thinking about the relationships between these legal regimes. The rules, studying norms and rules of responsible behavior to try to reduce risks of misunderstandings between states. Now you might be saying, okay, how would these laws conflict? Well, the classic example involves military astronauts. So many states use military astronauts because of their qualifications through the military and their civil space programs. So outer space law tells us that astronauts are envoys of mankind. They have to receive certain support, they're returned to their home state. But then we have the law of war rules concerning combatants and prisoners of war, and they certainly might conflict between the two. So that's a classic example that everyone brings up. So the goal of this presentation is not to solve every single conflict, and we're not going to go through specific examples like that or get into the weeds, but really it's just to offer a framework when these things come up, how to apply an analysis using the ILC framework. It's just one way to look at these problems and solve these conflicts. So the two regimes we're talking about are international outer space law, which we'll cover briefly, and the law of war. Now I'm using the term law of war. There are a lot of different terms to refer to the various rules that apply to armed conflict. You'll hear use ad bellum, use in bello, the law of armed conflict, and even international humanitarian law. So when I use law of war, I'm just saying that to encompass all those types of rules and principles and laws that might apply to various military activity involving armed conflict. So don't hone in too specifically on which term I'm using there. So you could look at this as a boxing match or some type of fight where someone has to come out victorious. Okay, we have this activity in space. Law of war says one thing, space law says one thing. Who wins? Which one do we apply? And that's what I'm trying to offer today is let's not rush into some type of conflict between the two. The ILC report goes through the importance of doing legal reasoning, trying to harmonize the rules first, trying to see if they can play off of each other before we just put them into battle and pit one against each other. Because really, if we make one victorious over the other and completely wash out, then we lose all those laws, and they're not able to apply from the background and help us in our analysis. So really, we're focusing on harmony between the laws. This is ideal because it can fill in those gaps that we may need. So like I said, the framework I'm offering is based off of the International Law Commission, which, if you're not familiar with the International Law Commission, it's established by the United Nations General Assembly back in 1947. It's a group that they study and they make recommendations for encouraging the progressive development of international law and its codification. And so they'll study various things that states want them to look at and analyze, and then they'll typically offer a report with their suggestions and conclusions. And so in 2002, they initiated a study group to look at these effects of fragmentation on international law. And in 2006, they wrote a report, which this presentation is based off of, And it was heavily written by its chairman, Professor Marty Koskanimi. And so we'll look at that and use that as our framework. So fragmentation it's this concept that modern international law is a compilation of various specialized regime structures. So we have international outer space law, we have international air law, we have maritime law, we have law of war and all the various different concepts within that I mentioned, like jus ad bellum, jus in bello. And so you have all these regimes, as the IOC says, that focus on different aspects. And now this can be a bad or a good thing, depending on your perspective. It can be bad because then we have these regimes, and we're like, okay, well, if there is a conflict, which one applies? It can also be a good thing because these regimes are specific to these interstate activities, and they can really address the problems that we need. Either way, it presents challenges. And so the ILC, the buzzwords are this process of systemic integration and harmonization. We want to avoid self-contained regimes that are isolated from the other regimes or from general international law and its principles as well, because we need general international law to apply. Typically, a regime like international outer space law, it can't cover every single type of activity in space. We have to fall back to general international law principles and concepts in order to fill in those unknown gaps. So the ILC uses this term spectrum of relations. So the first step is we have to determine the facts. Everything's going to be very specific. You know, as attorneys, we say it depends. And so every scenario, we're going to have to look at the facts, fully understand them, and then identify the relevant rules apply to that situation. Maybe the law of war doesn't apply. Maybe outer space law doesn't apply. And if one doesn't apply, then there's no conflict because we only have one application. So that's why we can't give blanket conclusions on, oh, which regime is supreme? Does outer space law win? Does law of war win? We don't know because it's going to be very fact specific. I mean, this is easy in the United States because it's certainly easier because we have state laws that can be preempted by federal laws. We have our court hierarchy, et cetera, but we don't have this in the international system. So that's why this issue is much more complex, and we need to look at this framework. So on the spectrum of relations, on one end of the spectrum, we have conflict. This is where, like the boxing match, we put the two regimes into a ring, we establish a hierarchy amongst them, and one invalidates the other. This is not ideal. On the other end of the spectrum, we have complete harmony. This is where both regimes, both laws apply concurrently, and there's no conflict between them. In the middle, we have sort of this relative priority where they're both at play, but one may be set aside temporarily and can influence the application of the other from the background. And so again, we don't want to automatically rush the conflict into the spectrum, invalidating the other, preventing it from assisting in this interpretation. So we place it on the spectrum by conducting a conflict ascertainment, is what the ILC describes. So really, it's making this determination on, do we have a true conflict, or is it just an apparent conflict? It just seems like there's a conflict. The ILC defines conflict as a situation where two rules or principles suggest different ways of dealing with a problem. So to do this conflict ascertainment analysis, it's important to find the obligations created by the laws that the states are obliged to follow, as well as the object and purpose of each regime to determine the scope of the conflict. And so we'll look at that and we'll see how they can fit together. And we'll do that through law of war and international outer space law. So if you've seen this type of discussion before, you may hear certain terms. We'll just kind of briefly cover them now, such as lex specialis. And lex specialis, I mean, to its basics, essentially means that if you have a generic law and then you have a law that's more special or to the point, that concerns more specificity, then the more specific law would apply in that situation. Lex posterior just means that later in time law would trump. You'll hear jus cogens in international law, which are the all supreme laws that cannot be derogated from states. And so obviously those would trump other laws, and then applying laws into their normative environment. And so I just bring these up right now because we can't jump to these terms in our analysis. We can't say, oh, we have a conflict, let's just start applying these various relationship techniques. We'll get there, but there's a few steps before that we can try to solve the issue without even relying on these. But I just wanted to bring this up so everyone's familiar with those terms. So, in summary, the whole process here is focused on international law as a system. So you can't just take one out and apply it. It's all applied as a whole body. And then to do this, we need to identify shared systemic objectives between these rules. It's a process where international obligations are interpreted by reference to their normative environment or the system. So this was just a brief overview of the ILC process on fragmentation. And now we'll look at each regime specifically to see if we can start to identify shared objectives to place them in the system. All right, so first we'll cover the law of war. It's evolved throughout human history, really, by adapting to regulate new means and methods of warfare that have emerged along the way. Now, I'm not going to cover law of war into the depth of the laws themselves, or even go through, the specificity of each Geneva Convention or Hague Convention. But I just want to give you an overall flow of how the law of war has developed throughout history. This is important for our purposes here in this presentation to identify the objectives of the regime. So definitely didn't have laws in the early times, but we did start to see civilizations placing rules and codes on its soldiers. So we have these early rules for soldiers. Even the art of war notes, it was forbidden to injure an enemy previously wounded, or it even states to strike elderly men. You start to see these virtues and values that are applied to soldiers in battle. And even from the early times, we start to see reasons for why do countries or nations or civilizations put rules on certain things in battle. Well, there's practical reasons, because by abiding to some sort of rule system, a military establishes predictability, it establishes order, especially with its opponents. It's kind of the golden rule, like, well, if I don't treat prisoners like this, maybe then I won't be treated like that if I'm a prisoner. So we start to see these just practical reasons for these rules, as well as humanitarian reasons for these rules. And early on, these are heavily based on religion and morality. With religious comes this just cause concept for warfare. If I'm going to engage in warfare, I need this just cause to back it, to give me legitimacy. For example, the Greeks and Romans, they wanted the protection of their gods in battle, so therefore they had to make sure that they had this just cause before entering it. The Bible documents how Moses and ancient Hebrews had rules for warfare and the spoils that come with it. There were early Hindu texts from like 200 BC that had rules for land warfare specifically. Muhammad's followers had conditions they had to satisfy before they engaged in warfare. So, like I said, heavily based on religion and these moral values on how we conduct ourselves in battle. Definitely not robust. So don't get me wrong, warfare was still brutal back in the day, but it just shows us how these concepts are developing to where we get to today. And then we have spurring off of that religion into the Christian influence in writers. So we have early Catholic philosophers. They were wrangling with balancing their beliefs in pacifism, no war, and the needs of the state to do what it needs to do. And so this balance we see is present today with the balance between a state and humanity. And so we're still wrangling with these same concepts. St. Augustine wrote, "Peace should be the object of your desire, war should be waged only as necessity." So here we're seeing concepts of military necessity, a principle we have today, where they start to be developed from this early age. And these early Christian developments led to the concept of chivalry amongst medieval knights. And so here we have soldiers acting honorably amongst themselves to their own code, even in war. Now, this can be a good thing because they abide by these rules, but it can also sometimes legitimize certain things because they were in accordance with chivalry, even though it may not be a honorable action. But still, war continued. It still looks brutal, but these principles are developing. So through that, we have our next kind of period of development in the 15th and 16th centuries, really led by Hugo Grotius, known as the father of international law. A lot of work on international law and where international law concepts start to develop. He wrote a multi-volume piece called On the Law of War and Peace. And he's really trying to take all of these codes and chivalry and all these things that countries are following kind of unconsciously amongst themselves. And he's trying to show that, hey, these are actually international law. He wanted to show they're not just moral codes, but they're obligations. Armies were becoming more sophisticated, large of conduct, enforcement. Start to see the development of courts martial to enforce violations of these laws. And so that's really the next big stage on that side. Then we start to turn to the humanitarian side of Henry Dunant, the father of the International Committee of the Red Cross. So he was just traveling in Italy. He witnesses the Battle of Solferino in Italy, where there's just mass casualties. The wounded are left uncared for, and he was just sickened. And he determined that this could have all been prevented. And so he developed the Red Cross, and his advocacy led to the first Geneva Convention. Next stage, we start to see codified codes in countries. So I give the example of the Lieber Code from Francis Lieber in the Civil War era for the United States Army. Then we start to see Hague Conventions, Geneva Conventions, arms control as the development of these means and methods of warfare increase. We start to see like arms control agreements. So Russia in the early times, advocated for these arms control agreements with like the developments of cannons and other means and methods of warfare. And so we're adapting the law to this technological advancement. And then kind of like the final moment in the law of war development, at least recently, is the World Wars, World War I and World War II. And we kind of have this reemergence of the just war concepts. We have the creation of the United Nations, when it's valid to go to war. So again, law of war just has two buckets. We've got the jus ad bellum, which is that's the development of this just war historical development. And now in modern day, we have Article 2.4 of the UN Charter, where states must refrain from the threat or use of force unless the UN Security Council is taking action or a state is exercising its inherent right of self-defense as reflected by Article 51 of the UN Charter. And then we have use in bello, and in this bucket, it's this humanitarian evolution of the law. So we have, Henry Dunant and the Geneva Conventions. Now this applies to any armed conflict, regardless of whether the use ad bellum was complied with. So that's just a cardinal principle in that bucket. Again, not going to go into too many specifics, but if you're unfamiliar with the principles of the use in bello, we have distinction, which is separating military objectives from the civilian population, military necessity, as we've covered through the history, but just one keynote there, it's not a justification to do anything you want. It still must be balanced with the other principles. If you have that military necessity to take action or use force. Proportionality is any collateral damage to the civilian population from attacking that military objective must be proportionate to the purpose of the attack. And then we have humanity, which is centered on reducing unnecessary suffering. And so states will comply with this by doing legal reviews of the weapons being employed in battlefield to make sure there's no unnecessary suffering being caused. So, closing out the law of war, what's the systemic objective that we can use in this analysis further on is that it's really a balance between idealism and realism. The idealists wish to eliminate violence and war in total, while the realists realize that war is inevitable. And the law of war really is the arbitrator between the two. So striking a balance between these military needs and necessity and the elementary notions of humanity is what I've identified as the law of war. So let's now proceed to an examination of international outer space law to likewise identify its objective. So clearly not as much extensive history as the law of war going back to the beginning of humanity, but really the origin started in the 50s and 60s, Cold War heavy origins. Started with the groundbreaking moments of human accomplishment in space, like the launch of Sputnik and the subsequent state reactions to those events. And this is not unlike the development of the law of war with its reactions to the new means and methods of warfare. Eventually, we get 5 multilateral treaties known as the Corpus Juris Specialis. And it's shaped by, like I said, the Cold War between the United States and Soviet Union. The late Professor Ben Chang states that we've got this universal desire for exclusively peaceful purposes, balancing that with preserving their country's need to explore and exploit all the military potentials of outer space. So again, we're seeing this similar balance that are developing between the two. For example, President Eisenhower promoted the concept of space being a sanctuary, but he did this in order to protect U.S. reconnaissance satellites. So he had a motive there. He also desired freedom of passage for these satellites. He wanted them to be able to fly over our adversaries, which is why he refrained from objecting when Sputnik's orbital path went over the United States, because under international air law, that would be a violation. But he was developing these concepts of freedom, passion for space law. So again, we have these peaceful purposes and a state's military ambitions being balanced. Early on, we had UN General Assembly resolutions in the early 1960s that started to declare these principles that would apply concerning states' use of outer space. And then these principles would serve as the structure for the 1967 Outer Space Treaty, which is still the most important source of law concerning space that we have today. Again, we're not going to do a deep dive on outer space law. Just know that the Outer Space Treaty is broad in nature, and it's a treaty on principles. It's kind of like a constitution, which has allowed it to age well with the advancements of space technology. And then the Outer Space Treaty serves as a framework for follow-on treaties, like the Rescue and Return Agreement, Liability Convention, Registration Convention, and the Moon Agreement. And so that's kind of the construct that we have in international outer space law. Yeah, so like I said, there's a lot to talk about in outer space law, but I'm just going to hit some of the highlights for our purposes. We have this concept of peaceful purposes. So we see this in the Outer Space Treaty preamble. Now, while preamble is not binding international law, because it's not in one of the articles, for our purposes, it can assist with treaty interpretation, because that's essentially what we're doing in this exercise. Article 31 of the Vienna Convention on the Law of Treaties says that we can use these for treaty interpretation. And then for our purposes, we can use it to sort out these relationships between the two regimes. International law applies. The Outer Space Treaty says this in Article 3, this principle that these activities in outer space will be governed by international law to include the UN Charter. This is huge for us and for our analysis, because it confirms that general international law and the rest of the international law system is at play to include the law of war. This article and this principle show that the outer space domain is not the Wild West. You hear folks say, well, space is the Wild West. We don't know because we don't have all the laws, but we do if we rely on these other regimes. And while a lot of the articles can relate to military activity, Article 4 is the most prominent because it directly addresses military activity with its provisions on weapons of mass destruction in orbit and military activity on the moon and other celestial bodies. Here it says that activities on the moon and other celestial bodies, they should be used exclusively for peaceful purposes. And now, since this isn't an article, this peaceful purposes is binding. What is peaceful purposes? Well, it's not defined. But again, that's intentional from the states because they don't want to constrain themselves too much. They want to balance this peaceful humanity concept with not constricting their own state's needs in the future too much. So they're trying to balance that. And then state responsibility. Hopefully I have time, but we'll do an example on state responsibility. I just wanted to point out that Article 6 is unique in international law, where it actually attributes space or state responsibility to non-governmental entities when they're carried on by, so responsibility for national activities in outer space, whether they're governmental agencies or non-governmental entities. Yeah, so just to summarize the outer space regime, we've got this technology, historic events that are bringing new questions in the law, and we can see these same balances similar to the law of war. Now let's kind of look at the harmonization framework. Let's go back to the ILC and focus on the relationship between these two regimes. So the ILC says the first step in our legal analysis is to determine which rules apply to the situation. Makes sense. So for the law of war, some could argue, kind of along the lines of the Lotus principle. Well, since nothing says that a law of war applies to space, we can't assume that the states are bound by it. But I think it's clear that the law of war applies in outer space domain. Like I said, you've got the Article 3 of the Outer Space Treaty that says general and national law applies. You've also got the Martins Clause and the ICJ nuclear weapons opinions that say the law of war applies to weapons of past, present, and future. So I think we're pretty solid to say that the law of war applies to the outer space domain. So assuming some threshold has been met where the law of war does apply, the threshold for the use of force applies, then we look to international outer space law. Now it's clear international outer space law applies to space. But one caveat there is perhaps it doesn't apply if it's been suspended for a treaty suspension. The ILC has other work on the effects of armed conflicts on treaties. And so if we have an armed conflict, Certain treaties, depending on their nature, may be suspended. Um, but a key thing here to note is that within those articles, Article 11 covers the concept of separability, meaning the whole treaty doesn't have to be suspended. Maybe just certain provisions are suspended during an armed conflict. And that's when we have to look specifically to the treaty, look at the draft articles, determine state's intent. But I just highlight that because it kind of echoes the themes of the fragmentation report, where let's not just throw the whole thing out. Let's look at each thing individually and try to allow everything to apply. So that's the first step. Determine which rules apply. So let's just assume we have some scenario we're looking at and both regimes apply. Then we go to harmonization and this attempt to harmonize. And this is the goal, not put them in conflict immediately, but try to harmonize them, because there should be a presumption against conflict, as Wilfred Jinks says in the report. So considering we just went through each regime and they have very similar concepts and objectives and purposes, it should be easy to harmonize these two regimes. Now, let's say we try to harmonize them, but we can't. There truly is a conflict. That's when we're going to establish some type of hierarchy amongst the regimes. That's when we're going to look at tools like lex specialis and and use cogents to determine, okay, well, if we can't do both, which one applies? With the caveat that, again, try not to throw the whole treaty out that is not on the hierarchy, but just try to set it aside for that specific purpose and then allow it to apply in other areas. Yeah, so just kind of, so we've talked about the report, we talked about this framework, but I think it's helpful to kind of see it in practice. What's an example of how we can do this? And now, like I said, there's a lot of specific instances, like how do we treat military astronauts and whatnot. But again, those are all going to be very fact specific. So I'm offering an example that's a little less fact specific and more just of a concept on how state responsibility would apply. If you're not familiar with the concept of state responsibility, we'll look at the draft articles from the ILC, which is considered, I think, widely considered customary international law. State responsibility just means if a state breaches an international obligation and that breach is attributed to the state, then they're responsible to the state, to the other state. So this is primary. So we have this primary rule. So just pick any rule in the Outer Space Treaty. If a state violates that and another state is a victim of, some type of damages of that violation, then that state is responsible. So then we go to secondary rules. And the secondary rules are, okay, now that it's been violated, we have state responsibility at play. How do we deal with it? How do we deal with this problem? And the secondary rules are provided by general international law, where we have consequences, cessation, reparation, restitution, compensation. We have all these general international rules that apply if we have a breach of an obligation. However, there are certain circumstances that preclude the wrongfulness of a state, like consent. Big one is self-defense, countermeasures, necessity, distress. So we have all of these exceptions to where a state would be responsible. And both the law of war and international space law heavily rely on these secondary rules of state responsibility, showing that they can be harmonized. So here's just an example. Let's say state A performs some type of act of aggression on state B, and they want to act in self-defense. So they want to exercise the right to self-defense under the jus ad bellum, but in doing so, it would violate some rule in international outer space law. So on its face, hey, we have an apparent conflict. The law of war says that I can do this in self-defense. The international outer space law says I can't do it. Well, since both regimes rely on these general international rules of state responsibility, it sorts itself out. Because as I said, self-defense precludes the wrongfulness of a state. So it avoids a conflict between these regimes. State B can take that action in self-defense and not violate or not be held responsible for its violation of international outer space law because of this reliance on general international law. Another issue that comes up is state responsibility. So like I said before, Article 6 of the Outer Space Treaty is unique in international law, where it directly attributes non-governmental entities to a state. And so the classic example here is, what if company X, who's registered and supervised by state A, takes some type of action that's considered a use of force against state B? What do we do? Does this bring state A into does it drag them unwillingly into an armed conflict? And I don't think it does. If we go through the analysis of the ILC, first, there's two separate issues. First, there's state responsibility. So if company X's actions are classified as a use of force in violation of the jus ad bellum, and state A is responsible for that, then yes, they're responsible. It's attributable to state A. However, it doesn't unwillingly drag them into an armed conflict. It just then points them to the secondary rules of state responsibility, saying they must seize the act, which are in the best position to control company X, and they have to offer reparation. You know, state A was aware of its obligations to supervise, and you know, company X acted another way, so it makes sense that they would have to offer these reparations. However, neither of these consequences under state responsibility involve the use of force or armed conflict. The ILC articles on state responsibility make it clear that all these secondary rules do not cover anything associated with the use of force in international relations and the legality of belligerent reprisals. These are governed by primary rules. So then we'll turn to the law of war. So in this scenario, yes, state A might be dragged into some type of reparation under state responsibility, but then we'll turn to the law of war regime to determine what, or state B will turn to the law of war to determine what its actions are there. Political factors, the jus ad bellum, to decide their response. And so the way I see it, it's two separate issues. When we harmonize them, we can do one process without allowing the other process and the other regime to do its job. So hopefully that was helpful. Again, not answering any specific conflicts between the two, but just wanted to provide everyone with a framework or just a different perspective that I don't think is talked about a lot, is this ILC fragmentation report. So again, thanks for tuning in. I don't think we have enough time for questions today, but feel free to give those questions to Major Greenert and I can answer them offline. So yeah, thanks again.